U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. So I have a good topic to talk to you about today. I'm also going to dedicate some time to answer your questions. But earlier today, I talked about the Biden administration, some of the immigration changes. So earlier this week, I talked about the immigration changes that are coming after October 1st. I've already talked about the work permit adjustments. So they're speeding up work permit processing times, trying to alleviate some of the burdens of immigrants and the burdens that are now being transferred to cities that have to support immigrants who are waiting for their work permits. They're looking to speed up processing times, and they're also looking at expanding lengthening the time that one will have their work permit from 2 years to 5 years. Now, the concerning part about this was they talked about expanding their procedures and to remove more immigrants and do it more efficiently and focus on removing those who don't have a legal basis to be here. Now, a few weeks ago, I talked about also the immigration, the Supreme Court siding with the Biden administration on their immigration enforcement priorities. And it seemed like there was a conflict between the two, right? They're looking at expanding the number of immigrants that they're going to remove, but at the same time, they have a memo which is still in force. So the Department of Homeland Security, one of the memos called the Mayorkas memos, and they have three different memos: one for government attorneys, one for the judges and adjudicators, and then one for the so I say attorneys, the judges, and then one in general referring to how they should be approaching and immigration officers. So one for immigration officers, one for and then one for the adjudicators on how they should be looking at removal priorities for certain immigrants. And when I look at the both, when I look at the memos, and then I also look at the expansion of the expedited removal, there is not much of a conflict between the two as I thought before. Now, one is the expansion of the removal is referring mainly to expedited removal. Expedited removal covers certain individuals mainly, and I'll go over who are the expedited removal priorities. That's where they'll be putting their energy into removing certain immigrants who don't have a legal basis to be. But even though they're focusing on that, they have to also make sure that the immigrant meets certain criteria before they can do expedited removals. And then the other, so the expansion of expedited removals focuses on those particular immigrants. And then the immigration enforcement memos talks about ways that immigration attorneys or the government attorneys rather, the ICE officers as well as the judges should be looking at immigrants in regards to whether they should even be removed, whether they should be granted what's called prosecutorial discretion to stay here. So they permission to stay here, and instead of being removed, they have certain special permission. They don't get status, but they get permission to stay here. They get the permission to possibly get their work permits and continue life here. And so the two memos, when you look at who gets this prosecutorial discretion versus who gets to go to expedited removal, they don't really intersect. And let me explain what I mean. There are different immigrants in those cases. So let's start with the priority, the Department of Homeland Security's immigration enforcement priorities. This is where they decide whether they're going to put someone through removal. So this is where they put them through court, they send them a notice to appear, or whether they're going to exercise what's called prosecutorial discretion. That means they're either going to cancel notice to appear, so they have to go through proceedings, terminate the proceedings, or not issue one at all. So when they are deciding whether they're going to move forward with removal, they are looking at prioritizing removal for certain individuals that pose a threat to national security. They pose a threat to public safety through their criminal conduct, or they are immigrants who cross the border without inspection or unlawfully after November 1st, 2020. Those are the individuals that are on their list for deportation, to prioritize their deportation. Anybody else, they're going to look at a number of factors, which includes the length of time you've been here, your family ties, whether you have the ability to seek relief, or if you do have a legal basis to stay here, in order to decide whether they're going to terminate the proceedings, whether they're going to grant prosecutorial discretion so you can continue to stay here. And under prosecutorial discretion, you probably would do check-ins with them on a yearly basis, but you would not be placed in removal proceedings. Now, when it comes on to the expedited removal priorities, there are only certain individuals that can go through expedited removal. Is where you will not have access to an immigration court. They will apprehend you, pick or detain you, and then send you straight out of the country without going through that extra process where you're able to ask a judge, a court, for relief. So this is where they're saying they're working on removing people who have not shown that they have a legal basis to be here. And that's where they're focusing on expanding that. But these individuals to expedited removal are individuals who they're just at the border, they've just come in at the border. That means they're arriving, they haven't even entered yet. So at that point, the CBP officer can decide whether they're going to turn them right back around. Other type of subjected to expedited removal is going to be an immigrant who entered the country without being admitted, or who basically came across the border without permission and have been here for less than 2 years. So if you've been here for more than 2 years, you cannot be subject to removal, expedited removal, where they pick you up, they send you out, right, within a matter of days. If you're here for less than two years and you did not come in with permission, then you can't be subject to this. Now, the other is if you are an immigrant who you were apprehended within 100 miles of the border within 14 days of entry, then you're subject to expedited removal, right? So expedited removal applies to these three categories. So you've been here for a number of years, you cannot go through expedited removal. At the worst, you have to go through the regular process of going through immigration court, being issued a proper notice to appear in order to be removed. But this is where it works to the benefit of those who have been here for a while, is that they're going to be applying the enforcement, the new memo guidelines to decide whether they're even a priority for removal. So as you can see, it's in a nutshell, the expansion of the expedited removal is on recent recent immigrants who have arrived here. They have been here on, without permission. They came across the border without permission, and they failed to show that they have a credible fear of returning to their home country. So there's really no legal basis for them to remain, right? So if you are outside of the category there, you're not going to be subject to expedited removal. And in this case, the memo, the guidelines of immigration enforcement still stand, where they're going to look at various factors to decide whether they're even going to put you through immigration removal proceedings. So if you are a law-abiding immigrant, you've been here for a while, even though you don't have immigration status, that's where the enforcement guidelines provided by Mayorkas is going to be to your benefit, is that you're not going to be at the top of the list for removal. So that is what I had to explain to you, just so that it made sense, right? Because earlier this week, we talked about their efforts to expand the removal process for individuals, and now we know who they're going to be focused on, and that the previous memo still stands, that they're not going to be focused on law-abiding immigrants who have been here for a while, especially those who have been here for more than 2 years. And keep in mind, if you've been here less than 2 years, you still have to show, they still have to show to put you through expedited removal. They still have to show that you entered the country without being admitted or paroled, right? That means you weren't inspected. So if if you came in with a visa and then ended up overstaying, you're not subject to expedited removal either, right? So it doesn't cover expedited removal, does not cover one who has overstayed their visa and you've been here, despite how long you've been here. All right. So now I'm going to answer some questions. Now that I've explained this and it's now making a lot more sense, I'm going to go ahead and just answer some of your questions. So let's see. Hi there, it's nice to see you, Jason. How long after the case approved do you get the green card in the mail in Florida? So I've seen it anywhere from 1 week to 4 weeks to get that green card in the mail. Hi there, it's nice to see you, and you're so welcome. I am so happy that I can give you information that's helpful to you. All right, put those questions in the comments because I'm here to answer your questions. So put those questions in the comments. If you got your work permit before the new law, does the 5 years still apply? So yes, so now keep in mind that the 5 years, you have the 2 years, but when you're renewing, you're going to get the 5 year. Assuming that at the time you're ready to renew, that 5 year timeline is still there, then you'd get the 5 year. No, keep in mind this does not apply to all work permits. It's for certain immigrants who are applying under certain, for example, adjustment of status, asylum, if you are an asylee, if you've gotten withholding of removal. These are examples of the individuals that will get the 5 year work permit. Now, I just filed for my husband and he got a 6-month visa to enter the United States. Where I was living when I filed his paperwork, I'm not living at that address anymore. How do you change the address? So, you are going to have to submit there. So if we're talking about being in the US, you're going to submit the AR-11 if you're changing the address of your immigrant spouse. If you would like to update your address, you probably have to call them. As a citizen, you have to call them and also make that update on your address. That green card and SSN can be sent to the new address. So let's see. Okay. Yeah. So now, if you're, as I said before, your spouse is now waiting for the green card, go ahead, change the address of your spouse using the AR11 form on the USCIS.gov website. But that's only if he's in the US applying um, for adjustment of status. Any updates on the visa? So this time. All right, keeping those questions in the comments. I'm here to answer your questions. So put those questions in the comments. All right, so I have a P1 visa that will expire in November. I'll be out of status by November. How can I get the work permit or extend my visa? So you'll have to work, make sure you focus on an extension and what your circumstances. Very important to get legal advice to determine how you're going to change your status or extend your visa. I don't know if you even qualify for that. That's where it's important. Make sure you do yourself a favor by scheduling an appointment. Now, if you're out of status, then the work permit just doesn't come like that because you're out of status. So that's just one thing I want you all to understand, that there is no such thing as saying, oh, that's okay, I'll just overstay my visa and apply for a work permit. That's not how it works. You have to, just like with everything else that you're applying for, you have to qualify. So, for example, you're applying to college, you can't skip all the education before college and jump straight to the to applying to college, right? You have to qualify, you have to meet the educational requirements. It's similar with the work permit in that you have to qualify in some way, whether through family, whether through employment, whether through humanitarian relief, like if you're afraid to go back to your country, and so you're applying for asylum and you can get the work permit that way, or you are the victim of trafficking, or and trafficking as in labor or sex trafficking. But it's not, that was a case where you could just overstay and get your work permit, I think everybody would be doing that. And it's just not that way. So, but what happens is when I take on clients' matters to get them their work permit, I've already done a detailed evaluation and I've determined that based on their background, based on their family relationships, in some way or for a benefit to get the work permit or the green card. So this is where um, making the investment and scheduling a consultation to figure out your options is a good idea, especially before you make any big decisions like overstaying. You want to make sure that it makes sense for you to do that and that you understand the repercussions associated with doing that. If you file for a family member out of country and you have waited past the time frame, how can you check if mail was sent? So you can now, if your family member is out of the country, if they're processing it at the USCIS, you have to get in touch with the USCIS. Maybe you can put in a case inquiry. Just depends on the processing time and whether you pass their processing times. You can call them to find out, make sure that you haven't missed any mail, and make sure that they have the right address. If you're outside of the country and now it's at the national visa stage, you're at the national visa center stage, you're going to have to contact the national visa center. Good morning. Would it be possible for my 20-year-old son to put in my documents? He turned 21 in January. So you must wait until he gets to 21. But the good news is you don't have long to wait. So your child must be 21 before they file. So at the time of filing, they need to be 21. Is it possible to expedite the work permit for a U visa? You can always ask for it to be expedited, and it just depends on the basis and whether, based on the basis, the USCIS will feel that it is warranted to grant you the expedite request. What do you do when your spouse no longer wants the relationship? He wants a divorce. So for me, on my end, when I represent my clients, just simply getting a divorce does not entitle you to an immigration benefit because your spouse wants to divorce you, because that is permissible. But if there is some mistreatment in the relationship, if your spouse, they file for they want the divorce, but in the process they've mistreated you, manipulated you, controlled you, subjected you to verbal mistreatment. Sometimes they use divorce as a way to hang your immigration status over your head. If you don't want to do what they want you to do, then they say, "Oh, I'm going to divorce you, and now you can't get your papers if I divorce you." That is mistreatment, and it can qualify to apply for your own green card process, get your work permit and travel document. So this is really comes down to your circumstances. Give us a call, schedule an appointment. Let's talk about what the facts are and determine whether you qualify for relief. What if I'm out of status, but I applied for VAWA based on my husband abusing me? What are the chances of me getting a work permit? So your chances are really good. Now, what you do get the work permit. Your spouse is a U.S. citizen. You apply for VAWA. You're supposed to also apply for adjustment of status. And you can, in the process of applying for adjustment of status, you can apply for your work permit and your travel document. So this is where I urge you to go ahead, call, schedule an appointment so you can get the right help, so you know you're doing it right. Because when we apply for our clients and we make sure our clients qualify for adjustment of status, we make sure that adjustment application is being submitted at the same time. What's the processing time for a U.S. citizen in Florida, for U.S. citizenship in Florida? And can you apply 90 days before the 5-year anniversary? Yes, you can apply 90 days before the 4-year 9-month mark. The timeline that I'm seeing now is anywhere from 2 months to 8 months to get citizenship. Applying for food stamps for my newborn, will that affect my green card? So it's as long as this is for your newborn based on their citizenship and their qualifications, then it will not count against you. But keep in mind that based on the current public charge rules, it does not, they're not going to use food stamps by itself against you, even if it was in your name. Go ahead, call the office. So I'm going to take pause here. Someone says they're going to call. We're looking forward to your call. So you can call 561-405-4889. I'll go ahead and put it in the comments, and it's going to be under immigration lawyer Sharifa. You can scroll through the comments and take the number down. Also on YouTube, Facebook, Twitch, you will see my number scrolling at the bottom of the screen there. Just write it down and give us a call. The staff will be more than happy to assist you with an appointment. Married to a U.S. citizen, doesn't have work and didn't file a tax, is she still able to file for adjustment of status? So if they require the tax returns to go with the affidavit of support, the affidavit of support is a crucial part of the application. Your application will not be approved without it. Now, you said she doesn't work. if she doesn't work, she doesn't make an income, and that is possibly why she hasn't filed a tax return, in that case, she can file this affidavit of support and explain why there's no taxes filed. Now, obviously, if she's not working, she's not meeting the income requirements necessary to apply for you. What in that case, you're going to have to find a joint sponsor who can step in to show their income and that they can support you in the alternative. Um, All right. So I sent my immigration paperwork, marriage based 9 months ago. I never got work permit, just an RFE for medical exam. I responded, it's 6 weeks now. Do you think I'll get my green card waived? So it sounds like it could be because usually when they're asking just for the medical, it means that they are, after looking at your application, all they want is the medical to make a final decision. So you may very well be getting that green card in the mail. If my brother and I have different last names, can he apply for residence if we can prove by DNA test we are really a brother? Yes, absolutely. So if you can show that your siblings, even if you're half siblings, you can still qualify for the sibling petition. But let me just mention here that the sibling petition takes a minimum 14 years. So it's not going to be a quick solution here to get permanent residence if you're already here in the US. All right, so that's going to be it for me today. Thanks everyone for your time. Go ahead, call, schedule your appointment. My schedule is filling up and I do want to assist you as soon as possible. So go ahead, call, schedule, and we can talk about your particular circumstances and figure out if you can get that work permit. Um, or get status here. You can get a status that can lead you to the work permit. So give us a call and we can talk about your situation because really that's the only way to know whether you can qualify for one of the options that I evaluate for. And I do ask extensive questions to figure out if one of those, if you do answer yes to one of those questions, whether you have a chance, even if you're out of status, to get relief here. Thanks so much for the love. I hope to see you on Monday when I'll join you for a live and we'll talk about your questions and I'll also give you updates. As you can see, we are on the brink of a government shutdown, by the way. And I did have a live this past week, during the past week about this. I'll see if I can release those lives over the weekend. But I want you to know that when it comes to the Immigration Service and the Department of State that deals with visas, they are not going to be closed down or the employers are not going to be furloughed because they're self-funded. So they depend on the fees that are paid by the applicants to run the office. Now, later on, if this goes for very long and they run out of funding, then that could be another issue. But for right now, make sure even though you may see a government shutdown happen, in a few days, don't think that means that the offices are closed and you don't have to send your applications in. When it comes on to the court, immigration court, make sure you call the immigration court. And use your A number to find out what's going on with your case. Don't just assume that you don't have to go to court. Now, the courts could be affected because the judges are considered, the judges and the government attorneys are considered federal employees, and that means that they may reschedule or cancel some court hearings. Now, when they're prioritizing some, so for example, the detained court hearings, so those that are detained, they're still proceeding with those, but the non-detained immigration court hearings, those may be put on hold. during the shutdown. But call the court to make sure first. Don't just watch the news, or if you get correspondence directly from the court, then you know, but don't just assume, because it's so important for you to make sure you're following up with your court hearings, that you're not out on them. All right, thanks again, everyone, and I will keep you updated on Monday. Have a great day. Bye-bye.